Whakataka te hau ki te uru, whakataka te hau ki te taonga. Kia mā kinakina ki uta, kia mā tarata ki tai. Kia he aki ana te atapura, ki tio, ki hoka, ki hauhu, ti hei, mauri ora.
Kia ora.
Okay, good morning, everybody. Welcome to day 2 of hearing 15C. We have Cavalli Islands sitting for us to present their submissions. Mr. Webb and Mr. Putt, welcome.
Thank you.
I'll hand it over to you.
Yes, well, thank you, Mr. Chair, and good morning, everyone. Let's say that even though there's been substantive agreement between ourselves and the council on our plan change request, we felt it really important to appear this morning because this is the end of a 20-year program. Mr. Putt will tell you that commenced in 2005. And that underlines just how thrilled we are to have reached a solution on this long-standing issue. The resource consent that is underway and been implemented at Matari was actually signed off by Mr. Watson, Commissioner Watson, in 2006, and that was always dependent on an appropriate zoning being placed over Matari Bay to enable the lots to be sold and dwellings to be constructed on them. There's been a lot of history at Matari Bay, not all of it good. We traversed that in our submissions at the original hearing. But the point I really want to make is that so far as we're concerned, that this plan change process has been an exemplar of how plan changes should work throughout New Zealand. From our perspective, what happened was we had a notified plan change, we had some disagreements, we made some submissions, and then I think because of the experience, I don't want to be too sycophantic about this, but it's true. The experience of the panel hearing this plan change saw exactly what was going on and told us I won't talk about it. And I think what the big change has been is that we've got the people that we were talking to aren't the people that we were talking to previously, and so we're able to have some sensible discussions. We're able to have some good solutions, and we worked our way through those relatively painlessly. And with the assistance of Mr. Putt, came up with a solution that didn't require a massive change to what was there. We just had some clever draft that was ultimately endorsed by the council. I just wanted to register the importance of today for Valley and Mr. Putt in particular, but also a big thank you to the staff and to the commission about how this matter's resolved itself. So I don't really have anything else to say. Mr. Putt just wants to fill in some gaps on some of the details. I'm available to answer questions if there are any.
Kia ora koutou. 20 years. I think about a lot of the people who have been involved, particularly in Ngāti who have passed on since then, and remember them. The difficulties they faced with bad advice that sent their money down the pipes. And this development was a way of rescuing their hapu mana that released this little piece of land but allowed them to hold on to everything else they own in Matari Bay. So this subdivision became critical to the release of the debt that Ngāti incurred through bad legal advice, and successfully that has all now been resolved. And interestingly, the bad karma that came out of that was visited upon, first of all, Bridge Corporation, then Instant Finance, and then strategic finance, who all went down the tube funding this development in the hope of making a lot of money. And it was rescued in the end by Peter Krause and his and the wealth he was able to bring to the situation, picking up the entire property from or the development from the receivers of strategic. And interestingly, his interest was here because he married a woman from Ngatikura. So there was an important connection for him in this matter. So the best thing about today is we can resolve the zoning and push on. We've resolved issues with the council on the management and ownership of the wastewater inflow system. That's all been settled and it's now operational. So that in the next rating period, a special rate can be applied to these sections to collect a wastewater levy. I did find a map which I think will be extremely useful. I passed a copy on to Ms. Trinder. It's a JPEG copy, so her drafts people in the mapping section of council services should be able to use it. So the map is the plan is the one that has been tabled. Those are the areas in blue are the areas which we consider should receive a settlement zone. My supplementary and rebuttal evidence really just sets out the minor changes that I considered would make the difference between the Kerikeri request of using the residential zone over this area with the council's position, which we agreed to in discussion, that the settlement zone was more appropriate. And these minor changes simply ensure that a single dwelling on each of the approved lots would remain as a permitted activity provided it met the development standards. And that is all acceptable. And Sarah has owned up those words in her section 42 report, and I agree with her final wording. So there's really nothing more for me to say on this matter other than to say thank you, and thank you to the planning team for being so efficient in the consultation process.
Thank you very much for your presentation. It's really good to see agreement happen after such a long time. Commissioner Watson was involved at the beginning. I was involved as a council consultant processing a plan change under the operative plan, and here we both are here at the end seeing this thing resolved, so it's quite good.
Yeah.
I just want to see if the staff have anything to add. Any comments from council staff on this matter, or I just
yeah, I was just going to ask a point of clarification around stage 2. You say in your rebuttal evidence that it's under construction. Could you just confirm what you mean by construction?
But can you speak up a little? Just like you see stage 2. Yes.
Can you just confirm what the construction?
Well, the Kerikeri has obtained engineering approval for the construction of stage 2. Stage 2 was initially consented as part of the overall subdivision in 2006. The last summer, the pine trees that remained on that area were cleared, and the land has undergone de-stumping, and some landform earthworks have been done to create the basic platform for the lots. This summer, the road formation and the infrastructure will be put in place. And so by the end of summer, let's say by about April next year, I expect we'll be able to lodge the section 223 requirements to confirm that subdivision conditions have all been met.
Thank you.
Okay. That's where we're at.
And thank you for this plan. Just to clarify, I mean, the blue key there, that says proposed coastal residential zone. Is that meant to say settlement zone or?
Settlement zone.
A drop date,
This is an old plan. Yeah.
but we should interpret that blue area as being settlement zone.
Yeah. Yeah.
It's interesting looking at the team district back in 2006, the controls implemented then. It was so good that they're more onerous even than the settlement zone provisions now. That's what's amazing. Thank you very much.
I'll see if the other commissioners have got any questions for you.
Very positive,
There it is.
very positive.
Yeah.
Yeah, just pleasing to see the thing brought to a close. Been a long process.
We're there.
Well done.
Thank you.
Well done, and yeah, I do know a lot of the old people. They're in the Urupara at the bottom of the hill that have passed on since,
Yeah.
and it's very pleasing to see the result. And thank you for your thanking our staff carrying on through the process.
Well, I think that's been one of the most significant changes.
Yeah.
It's great.
Thank you.
Well, thank you very much, and thanks for making the effort to come up here
Yeah, well,
to essentially say what we agree, but it's really good to see you here in person. Wish we had better weather. It was a day like yesterday.
Oh, you leave alone. A drought's broken. We need the rain.
And we should also pass on the sincere thanks of the Cavalli directors
Right.
for the ability for this independent hearing panel to resolve these matters.
Just one thing on behalf of the council, given the drama that there was about the wastewater connections and being that operational, it's great to see the positive feedback from our staff
Yeah,
for this process. So thank you for those.
we all got there.
Yeah.
It seems to me that all the difficult people have got.
Well, but it wasn't always the staff that had the truth. And the people actually doing the work with something.
Congratulations for your perseverance. The period.
Thank God, very good. Thank you.
Thank you.
It's a really good start to the day.
Just hope, doesn't get us down. That's too much rain. Back you down.
So our next submitter is Neil Construction Limited. Please come up and have a seat at the table. It's the fifth time we've seen Neil Construction. Welcome. I'm sure you know Commissioner Watson and myself reasonably well, but he's currently Felicity Boyd.
No, what is?
Steve McNally, and also another one of our councillor commissioners. They keep a good close eye on us and commissioners.
Excellent. I guess you'll have copies of my submissions. Oh, thank you.
Okay, Ms. Swan, we'll hand it over to you.
Okay, so I think you all know now, my name's Vicky Kwan, and with me today I have James Brick, who is a development manager for Neil Construction Limited, and Philip Brown. So this submission relates to approximately 156 hectares of land in Kerikeri, about 4 kilometres north of town. The area of land is shown in outlined in blue in a little diagram on page 2 of my submissions, just there so easy to look at. And then you'll find the last couple of pages of the submission set out in table form, just a list of all of the things in that blue area. So this area has been developed over time for large lot rural residential purposes. The existing lawfully established and consented development comprises 1 house per lot, varying degrees of landscaping. So Neil Construction seeks this area be zoned rural residential zone, as opposed to the rural lifestyle zone, which is the notified zoning. So part of this land is known as the Rangitane River Park, and it has been developed in stages by Neil Construction since 2013 and acquired the land in 2008. So like the previous submitted, this has been a long run project, which is again reaching its final stages. So the final stages, stages 3 to 6, were consented in May this year, and work to give effect to the consent is underway. So across this area, lot sizes vary. Larger lots in the coastal environment overlay, transitioning towards smaller lots in the centre of the land, away from the various boundaries. So principal reasons for this submission are that the purpose of the rural residential zone more closely aligns with the consent development and lawfully established use of the land. The rural lifestyle zone would enable activities that are incompatible with the consent development and established uses. The development standards of the rural lifestyle zone also may not align with the consented development and result in otherwise unnecessary applications to use consent. Zoning within rural residential would result in a coherent pattern zoning with natural and defensive boundaries comprising the Rangitane River and public roads. To put plainly, the rural residential zone is a fit for the established and consented land use. The rezoning is supported by the reporting planner based on the hearing panel's guidance criteria. In paragraph 10 there, I just quote the conclusion that the more productive zone would not be appropriate in this case. So when considering the proposed zoning against the statutory framework, the rural residential zone is the most appropriate zone. On page 4 there, we just touch on some of the statutory criteria for district plans, considering the proposed zoning against the national policy statements and Northern regional policy statements. So none of the national policy statements particularly touch on land or any particular relevance, in particular, not measure urban development or highly productive land. The national policy statements regarding fresh water and biodiversity were dealt with at the resource consenting stage, and those matters have been considered and development authorised. The objectives and policies of the regional policy statement are very neutral with regard to the zoning of the land and don't lead in any particular direction. So all of the submission land has either been developed or has consented to be developed, and as such, the actual and potential effects of that development, including the effects of the development on free water and transport infrastructure, have been considered and found to be acceptable. In terms of future effects, there is limited realisable opportunities, if any, further subdivision. And so overall, as set out in Mr. Brown's evidence, the rural residential zone would be a more efficient option for the land. And this is primarily because the rural lifestyle zone is misaligned with the approved access. So that is my submission. So unless you have any questions you would like to ask me now, I would like Mr. Bragg to make a brief statement.
Okay, I think we'll probably hear all the submissions and evidence, and then we'll probably have some questions. Let's proceed.
Okay, good morning, commissioners. I'm assuming that my main evidence is taken as read, is that correct?
Yes, we have read your evidence.
My name is James Rick. I'm here today as the Subtitles representative and as the development manager responsible for our Ringatangi River Park project, which I have detailed knowledge. This development has progressed in stages with resource consents granted for over 170 residential lots. The matter before you concerns the proposed rezoning of approximately 156 hectares of land, including our holdings under the proposed district plan. We oppose the proposed rezoning to rural lifestyle zone and instead seek that the land be zoned rural residential zone. The rural residential zone is the only zoning that accurately reflects the nature, intent, and consented form of development already enabled on our land and the wider submission area. Our land is being subdivided into large residential lifestyle lots centred around single dwellings in full accordance with the Environment Court's decision. The zoning must align with the actual and intended land use outcomes. By contrast, rural lifestyle zone would enable activities and development incompatible with the character and expectations of the consented development. The land is not rural in nature, it is residential in purpose and function, albeit with large lot sizes. Applying the rural lifestyle zone introduces several risks. It creates land use conflicts where none currently exist. It adds unnecessary administrative complexity and confusion for both council and government. It imposes unjustified burdens on purchasers requiring resource consents for activities already permitted. And down zoning in this context is highly unusual, especially where no natural gas exists. Regarding the most recent consent for Ringatangi River Park stages 3 to 6, issued by the Environment Court on the 16th of May, I would like to update you on progress and to assist with that. I've actually got a handout here. So this aerial photograph of the site was taken on Saturday, the 20th of September, so just over a week ago. It shows the bulk earthworks substantially complete, and the roads and the jolts have been cut out, and there's a layer of metal across all stages of the development. Planting in the 19-hectare reserve that is to be vested in council is well underway, with approximately 70% of planting expected to be completed shortly. Mulch has been laid in the substantial on-lot planting areas for stage 3, with again 70% of the planting anticipated to be completed this season as well. Civil works for stages 3 and 6 are scheduled to begin in November and be completed by June 2026, with titles for 46 lots expected in the second half of 2026. In summary, I respectfully request that our land and wider submission area be rezoned to rural residential zone in the proposed district plan. This will ensure the planning framework reflects the lawful development that has occurred, provides certainty to landowners and purchasers. Thank you.
Thank you. Is this all for you, Mr. Brown?
Good morning, commissioners. You've obviously seen my evidence from previous later, so I won't go through it, and this one is correct, sort of covered a lot of what I would have dealt with anyway. So maybe I'll just explain what I've done. I'm on page 4 of my evidence. I've set out the reasons for the rezoning request in summary, and then I've explained those in the following pages. I have filled out in table form at my evidence, the panel's evaluation criteria for rezoning changes. At the bottom of page 8, I've provided a section 32AA evaluation for design change, which we need to do. Essentially, I think that's really the essence of plan change and plan making. It's about dealing with section 32, in this case 32AA is really the RMA for dealing with changes to plans. I have a conclusion, which is that in my opinion, the identification of the land as rural residential zone is more efficient, effective, less cost and more benefits than maintaining a rural lifestyle zone under the proposed district plan. And those reasons I consider the land should be identified as rural residential zone. In addition, I did provide some analysis of potential future subdivision that might be possible in my discussions with this person. She's produced that as part of that 642 report. I have provided a very brief reply evidence as well, basically just confirming that I've read this piece of the 42A report. It was comprehensive and considered, and I agree with it. I would also say that I thought the process that was used here was very efficient and helpful to be able to provide applicants evidence first, so that considered that there should be on it, and enabling negotiations or discussions between
Well, thank you very much for that feedback. It's good to hear that. And we've had lots of good feedback about the process, even from parties that haven't got exactly what they wanted, but at least they got the opportunity to articulate. I was going to ask you a question to sort of give us a bit more that detail about those existing lots that you subdivided. Perhaps maybe that you're here, you could take us through your reason and how you responded to Ms. Pearson's questions. Well, once you've satisfied her, we sort of like to understand your reasoning as well.
Well, Ms. Pearson and I discussed it, and we asked summary around what future potential subdivision there is. Given that essentially anything below 4,000 square metres is discretionary, it's the starting point is that it would be difficult, or potentially it's challenging to get that over the line in any circumstance. There was a presumption, I think, of a discretionary activity that you're not necessarily going to get there, and you certainly have to make the case. There are a limited number of sites that are bigger than 4,000 that would have potential. There are no sites bigger than 8,000, which would allow private subdivision, at least within new construction's land limitations. I started off just thinking about those things more generally, but as I got more into it, I realised I really needed to do a bit of a science analysis. And there are pretty good reasons, I think, why some subdivision might be possible, but I think they're very limited. There's a lot of planting covenants that are on the site as part of the Environment Court's decision and this initiative in terms of way to set out the land. Those really mean that there's not going to be a lot of land that's available for surface land on lots. It's also on-site wastewater, obviously, which requires irrigation fuels. There are covenants that say that you have to have low fencing on boundaries, so that's going to encourage people, I think, to plant up the boundaries to give themselves a good price and separation. Again, it's going to take more land. There are yards on some of the road frontages, which really mean that there's not a lot of surface land. And I think another issue is that we'll buy these lots. It's highly unlikely a developer would look at sort of a speculative thing and buy a lot and try and subdivide it because it's discretionary activity to subdivide. It might cost involved. So it would be possibly owners who buy and leave that thing subsequently about if he will subdivide, but in the way that someone would logically lay out the sites, given the 30 by 30 metre building platforms, they'll put it in the middle, to provide separation of amenity. And by the time people have gone through and done that, it's not realistic to think that there would be any sites, I think, that would have into beyond that sort of initial phase. There are other lots, obviously, in the previous stages, which some of which are bigger, some of which are smaller. But again, I think the way those have been laid out probably is not conducive to subdivision. I couldn't say that there would be no subdivision in the future, but I think it's going to be very, very.
I think this aerial photo sort of helps a bit because you can see where a number of the dwellings have already been placed. I think that supports your position that, you know, when you've got a large site, you tend to want to be building a platform somewhere near the middle.
Yes.
And it seems to me that's what a number of properties. Under the consents that granted sites, were the building platforms approved as part of those consents? Are they mandated to be in the location they are, or some flexibility?
There's a bit of flexibility. It's mainly around setbacks and boundaries and things. Largely they are, and geotechnical work is really looking at certain locations on sites.
Yes. Okay. Thank you. That's my only question. I'll see if the other commissioners have any.
I had a supplementary question to that regarding land use. So subdivisions, one aspect. What about multiple residential units?
It's not provided for, it's one house per site.
Just one house per site.
Yeah.
And only in terms of the additional traffic for the subdivision, because we have a one-way bridge, one-lane bridge, that there's a lot of traffic already occurring in traffic will occur as the stage is developed and subsequently built on. That was a concern that I've heard from the community and wasn't addressed as part of the conditions of your subdivision currently.
Yeah, I think what I would say about that is that issues such as provision, export, those type of issues will be subdivision. So all those matters have been considered the rezoning makes no difference.
No, just to say the additional information you provided, that additional analysis is quite important. And it's one thing to get a planning statement or a statement of evidence from anybody, but then that just sort of nailed things, particularly in terms of responding to the questions from the officer. So that was useful. Thanks.
I noted that you were very specific in that no sites over 8,000 that need housing owns. So it relates to the prior lots that are already developed that may have that subdivision potential. Is that what you're saying?
My memo decided related to subdivision. So there are some lots that are bigger in the earlier stages of the development. So in stages 2 and 1 and 2. But again, I think while you couldn't rule out subdivision, I think it would be unlikely or very, very mainly because of the size.
And I think the other part of the building platform, I think there were view shafts that had to be maintained as well, situation you build buildings. Is that right?
I'm not aware of the earlier stages whether they have those covenants on the historic line.
I will ask Mr. Rigg a couple of things. I'll ask him. And the last one, the last point I got is really, if you think about housing development, infill housing across New Zealand, you know, development by the rear sections of 2 properties side by side, and then develop. Nothing's impossible, but but you're saying additional covenants are in there by the environment court process of 1 house per lot.
Yes, and no minor limits as well.
And then the transport issue, the landing road bridge, that is a problem, and I'm surprised the environment court dismissed it as irrelevant because what.
Dismissed might be too strong a word. They heard expert traffic engineering evidence and on that determined that the effects would be acceptable.
I will disagree. I can change my commentary around dismissive to, I'm surprised it was not deemed relevant because that's a problem right now and it's going to get worse with this development. Mr. Rigg, the reserve planting, 19 hectares underway to be vested in council. Who will maintain that reserve, weeds, pests, etc. going forward?
For the first 5 years, we have a maintenance and on the reserve. There's 3 large covenanted areas within the reserve, and there's a public area. The 3 large covenanted areas are going to be managed by a private trust, which the community groups are putting together at the end of that 5-year period. And all fencing is covered by that maintenance under the private trust, or that backs onto the reserve. The council is only left with that large public area of to look after, to essentially mowing some grass, and it's got a walking track as well, all weather walking track.
Mowing some grass doesn't sound much. I think we already mow around about 360 hectares. It cost a lot of money. That little plantation in that corner of land, Capiro, and that'll be Reckless Road. Is that protected as well?
Yes, it is.
Yeah, there's some tree in there that's pretty special apparently.
Yes.
All right. And the question related to the bridge, yeah, that was, you've obviously managed to sidestep that one earlier.
But yeah, as Vicky said, the evidence was presented and it wasn't considered to pose a significant influence.
Yeah, no, it's, as a councillor, the ratepayer will end up dealing with that at some stage, and so on. The questions are related to future long-term operational expenditure and capital expenditure, which will land there. So it's something we'll take up with our planning staff. Make sure you don't let these things happen. Thank you.
And before we wrap things up, I'll just ask the council officer, particularly Ms. Pearson, have you got anything further to add? Any Brown's further explanation about or any of the other matters?
Not anything in particular to add. I'd reiterate that I found it really helpful to have the opportunity to discuss this with Mr. Brown. One of the evidence was received in June, and a lot of the questions that you've asked him today were the same ones that I asked Mr. Brown when I first looked at it. And the 2 things for me were future subdivision potential. Is this upzoning actually going to create more lots perversely than, because I've got a lot of submissions that came in front of me saying, just zone us what we are. We're already here, just zone us what we are, but actually those requests resulted in quite a bit more yield. Whereas this was quite different in that I wanted to satisfy myself that it actually was simply matching it to what was already there as opposed to enabling more yield. And in terms of those earlier stages, I asked the same questions about what about those larger lots, but we did note that those larger lots are in the coastal environment overlay. So in terms of the controlled pathways to subdivision, the presence of the coastal environment overlay for those larger lots actually puts another layer of protection over it again, so all subdivision becomes discretionary. So in that sense, there are discretionary subdivision pathways across the entire area, but I couldn't see any controlled pathways. And from a consistency perspective, for all of the rezoning requests, what I was starting with was what is the control, what would be granted kind of almost as of right that couldn't be refused. And so that's why I was asking Mr. Brown to satisfy what's the control pathways here, and we both came to the conclusion that we couldn't see any.
Thank you very much. Well, finally, I just think, congratulations to both parties, council officers and the submitter. This is the process that we hoped would occur. So you're the perfect example of submitters coming together with council officers, resolving your issues and presenting us with a very, very easy decision to make. So thanks very much. I'm glad you've enjoyed the process. It's not often you have people in front of panels saying, I enjoyed the planning process. So that's a really good outcome as well. So thank you very much.
Thank you.
Session.
Yes, I think we probably just got to look at the inputs.
Yeah, so I'll just stop the recording.
This is what happens when you do your jobs really efficient.
Yeah, stop